Bro, this is a video game website. Take this to YouTube or something. I agree.
Trump's legal team facing a very busy 24 hours ahead. Trump's lawyers are expected to appeal 2 decisions to remove him from the primary ballots in Colorado and in Maine. With us now to explain all of it, CNN senior legal analyst Ellie Honig at the Magic Wall. Really, at any moment now, it could happen at any moment. Yeah. We expect the appeals, a appeal, 2 appeals. We'll have to wait and see. Just to step back, though, what's the landscape right now in this new year?
Yeah, Phil, so the 14th Amendment, Section 3, has gone from relative constitutional obscurity to the spotlight very quickly. Let's just remind ourselves what it says. No person shall hold any office who shall have engaged in insurrection or rebellion or given aid or comfort to the enemies thereof. Seems fairly straightforward. The problem is it is being interpreted and applied very differently across the map. Let's take a look at the current status quo. These 6 states have rejected challenges, efforts to try to remove Trump from the ballot. Some of them are still being appealed, Arizona and West Virginia. These 11 states, we've had challenges to Trump's eligibility brought, but then withdrawn by the challengers for reasons that are varied. Now, we have, of course, now 2 states, Colorado and Maine, who've decided Trump is off the ballot. He committed insurrection. 14th Amendment applies. We could see appeals in the Colorado case to the U.S. Supreme Court, in the Maine case into the Maine state-level courts at any moment. But as you can see, I mean, this map tells you all you need to know about just how much chaos there is state to state.
Do we have any sense of what Trump's legal team's arguments will be in the appeals?
Yeah, so this is a complex sort of legal question. There's a lot of different issues swirling, but let's break it down into 3 questions. First of all, who decides? Now, if we look at Section 5 of the 14th Amendment, it tells us that the Congress, meaning the U.S. Congress.
This is silly. He was not found guilty of insurrection. Case closed. I mean, I don't disagree with you on this either. I mean, like, I guess the argument is, like, if you're a bank robber, but you haven't been found guilty of robbing the bank yet, and you somehow are free to, like, walk into banks, should people restrict your access to banks a little bit? I mean, you haven't been found guilty. Like, I don't know. That's not how it works. I mean, the entire point is the entire point is that the historically relevant part of this is that it hasn't been used on people that were immediately put up for trial. You know what I mean? So technically, historically speaking, a trial is not a necessity. But I think that that's a dangerous precedent in general. So I don't know if I fully agree with that, is what I mean. Like, in theory, I don't agree with that.
Congress shall have the power to enforce by appropriate legislation the provisions of this article. Trump's team will argue that means Congress, and it's not up to the states. The opponents will argue, no, states can still make their own processes to go along with Congress. If that's true, if the states do have the right to do their own processes, that brings us to the second question: by what process? How much due process is owed?
The argument is it's self-executing, like you can't run for president when you're 25 years old. That requires no conviction. There will be due process requirement. Yeah, the difference between someone being 25 and someone aiding and abetting in an insurrection is that one does require conviction, the other does not. That's the difference. Also, not 25, 35. I don't know why I just read that and said 25. But which Confederates were tried and found guilty of insurrection? No, I agree. I agree in its application. It was not utilized in that way. I just don't agree with doing it that way. That's my point. You get it? I think allowing people to treat Trump like he's guilty before he's proven guilty is a slippery slope that racial minorities. No, I mean, no. This argument always goes back to racial minorities and marginalized communities and blah, blah, blah. It's like, oh, you can't do this. Can't have gun restrictions because then it'll be used against racial minorities. Like, there are certain instances where restrictions and the application of the rule of law is a necessity regardless of how white supremacist the system is, that might actually bastardize it and weaponize it. Okay? You don't make that argument for, again, seatbelt laws, because, like, black people are more likely to be pulled over for any kind of restriction, any kind of rule that might be applied to them, where they can just claim, well, you're not wearing a seatbelt. You know what I mean? It's the system itself that is white supremacist. There's obviously differences between that and, sentencing disparities between crack cocaine and regular cocaine. Obviously, that is directly on its face a white supremacist invention. So overall, there's a couple different aspects of this. I do personally think the gun thing is a bad example because it's not gun control itself, but the enforcement. What do you mean? Trump does not need to be convicted to be disqualified from holding office. Just read, dude. Brother, I understand that. I'm saying I disagree with it. Why are you yelling at me? Am I not allowed to disagree with this? Why are you getting so mad? Read the 14th Amendment, Section 3, dumbass. Trump does not need to be convicted to be disqualified from holding office. Just read, dude. Here's a fast historical overview of the 14th Amendment, Section 3 by a historian that makes some of the same points you are making. Disqualifying Trump via Section 3 of the 14th Amendment by William Hoagland. Okay, I disagree with this as well, but I think it's objectively hilarious, so who's to say if it's right or wrong? I mean, that's the second aspect of it, which is that the reason as to why they are mad is because most, if not all, Trump supporters are deeply insecure and defend that piece of shit with passion because he is their entire identity. Certainly, but also, listen, I think there's two different things here at play. One, as someone who doesn't believe in, like, the American institutions, of course, I'll sit back and, kick my feet up and enjoy the show and laugh about whatever the outcome is, because either way, one party is going to get upset and it'll be funny. But having said that, if you were to ask me what my genuine perspective is on this matter, do I think Trump should be kicked off the ballot? I think Trump should not be kicked off the ballot. I'm a firm believer that you should literally be able to, once again, one of the only American pro-prisoner reforms that we have, or something that's in the law, is that you can, even if you can't vote, you can run for president from prison. And I think that's a good thing. I don't think it's a bad thing. I think it's a good thing. Okay? Now, this has nothing to do with that. Okay? Before chatters who are, this chatter in particular, who was like rushing to dunk on me on this, I know that wouldn't change this decision. Oh my God. I'm gonna put a 1 minute timeout on you because I'm gonna put a 1 minute timeout on you because you're frustrating me, because I feel like you're yelling at me with your caps log, frothing at the mouth at, like, showing how you want to prove me wrong on something before I can finish my point. That, what I just described to you, that you can, even if you can't vote, which you should be able to, even if you're in prison, by the way, you accuse him of yelling at you before he used caps lock. No, he was using caps lock. And that is yelling. This is the best way that you can describe yelling in chat. And also how fast you're typing, how much you hit the enter. People are coming at you for bizarre reasons right now. I know. I think people are very excited at the prospect that I'm, like, finally reading chat again and responding. So everyone is, like, getting into it. So what I was going to say is, I think that's a good idea that prisoners should be able to run for office, and they should also be able to even vote, right? And beyond that, I think that disqualifying someone specifically because you believe that they've aided and abetted an insurrection, which I believe Trump did, especially before they were convicted personally of said crime, and what the severity is, it needs to have a super high standard, super high bar to clear, in my opinion. There's a move on to invoke Section 3 of the Constitution's 14th Amendment ratified in 1868 to disqualify former President Trump from re-election. According to Section 3, a person who was sworn to uphold the Constitution when serving in the federal or state government and has then engaged in insurrection or given aid and comfort to insurrectionists can hold elected office in those governments. The original intent was to bar certain leaders from the former Confederacy from holding office. I think in a way I am doing what I get mad at liberals on, because I feel like this is something that Republicans would do 100%. Like, it's ideologically I don't agree. I guess, or in theory, I don't agree with it, but also it's like decent politics, I guess, even though it is still going to, such a soft leftist take, it is still going to not work because the institutions are already not really interested in upholding anything and instead just upholding right-wing hegemony. So the Supreme Court is going to defend Trump, and then this will turn into, look how they tried to massacre my boy, but Teflon Don still survives, and it will galvanize his base of support. That's what I think. I don't feel that way about the Georgia case, the RICO one. I don't feel that way about the other instances, like the federal cases, the criminal trial. I do agree with those. I think it's, you should hold him to account. You should hold him to the rule of law, right? But if you go, if you're too heavy-handed and it backfires, I don't know. We'll see. With all due respect, it's a civil matter, not a criminal one. He was found to have done an insurrection in a civil court and therefore cannot stand for election for federal office. Our Section 3 disqualification doesn't require a prior criminal conviction on charges that are insurrection. Well, you're not always going to be able to have a... The answer is no. The reasons are based on a combination of the basic structure of our legal system and the original meaning of Section 3. A standard element of our legal system is that the same events often give rise to both civil and criminal liability. For example, a person who commits rape, murder, or assault is subject to criminal penalties and also to civil suits by his or her victims. In such cases, criminal conviction is not a prerequisite for civil liability. Indeed, even an actual acquittal on criminal charges doesn't necessarily preclude civil lawsuits against the perpetrator. Just ask O.J. Simpson, exactly, who won, if the glove don't fit, you must acquit. Won the criminal trial, got a criminal acquittal, but then lost a $33.5 million civil liability. The criminal and civil cases were distinct, and the result of one did not determine that of the other. Same reasoning applies to Trump. The absence of criminal conviction for insurrection doesn't immunize him from civil proceedings arising from his role in the January 6th attack on the Capitol. Disqualification under Section 3 is a civil issue, not a criminal one. It cannot result in a prison sentence or other criminal sanctions. There are many reasons why civil and criminal cases arising from the same events might turn out differently. The most obvious is that a criminal conviction requires proof beyond a reasonable doubt, whereas a civil plaintiff does not and can prevail merely based on a preponderance of evidence standard. Slightly more than 50% chance that her position is right. For a legal standard to allow people who are convicted criminals to be able to become president or to be able to run and be on ballots, to then turn around and toss someone off specifically on a civil case where the standard is much lower, I think is not appropriate. Does that make sense? Even though this is directly a crime that pertains to winning or losing an election and then trying to have your way regardless by force. Does that make sense for chatters? This is my perspective on it. Okay, which is why I said a conviction, maybe that's a little bit different. A criminal conviction, maybe that's a little bit different. Even then, I don't know. In the Colorado Section 3 case, state courts found that the plaintiffs had sufficient proof to satisfy a clear and convincing evidence standard, a higher burden than preponderance, but less proof beyond a reasonable doubt. The lower standard of proof and other procedural differences between criminal and civil cases are justified by the generally less severe consequences at stake in the latter. Civil defendants don't risk the death penalty, prison terms, or getting a criminal record. In this case, Trump doesn't even face the prospect of forfeiting any of his property or paying damages. All he stands to lose is eligibility for various state and federal government jobs. There are situations where the consequences of civil liability are so grave that the civil-criminal distinction may seem artificial, as when defendants end up paying enormous damages that force them into bankruptcy. This is such a libertarian... God, Reason is a libertarian outlet, so it's really funny that they wrote this where... Like, only a libertarian think tank would write, bankruptcy is akin to the death penalty. You might as well. Yeah. Being relegated to the destitute conditions of poverty is akin to being shot by the state. That's awesome. A short prison term might be less painful than that. In addition to the general considerations about the structure of the legal system, there are also points specific to the original meaning of Section 3. None of the ex-Confederates who were adjudged disqualified during Reconstruction had ever been convicted of any crimes related to their roles in the Civil War. That strongly suggests the original understanding didn't require prior criminal conviction for insurrection or any other offense before an insurrectionist could be disqualified. They're comparing prison bankruptcy to losing the ability to run for office, not the death penalty, Lamau. No, they're saying they're comparing bankruptcy to going to prison and anything else, and saying going to prison is far preferable, or going to prison is like getting bankrupt. If not, bankruptcy is worse than going to prison. Okay? I am exaggerating by saying the death penalty because they brought up the death penalty up here when talking about what can happen in a criminal case versus a civil one. And I think that's pretty funny to be like, well, you know, bankruptcy is much, much worse than going to prison. Anyway. There are situations where the consequences of civil liability are so grave. Okay, general considerations about the structure of the legal system. There are also points to specific the original meaning of Section 3. None of the ex-Confederates. Yeah. In addition, it's important to recognize that tens of thousands of Confederate troops had surrendered under parole terms that arguably exempted them from prosecution for their wartime activities, so as long as they did not engage in further insurrection or other lawbreaking. The most famous example is General Ulysses S. Grant allowing Robert E. Lee, the Army of Northern Virginia, to surrender under terms that allowed each officer and man to return to their homes, not to be disturbed by United States authority, so long as they observe their paroles and the laws in force where they may reside. Good thing that surely none of them would then turn around and, I don't know, create and participate in the KKK. Whoa. Whoa. What? Would you get bored? Who you barking at? Who we barking at? Why are we barking? Okay, let's watch this.
Here, if we look, for example, at Colorado, look, These don't have to be criminal trials. That's the highest level of due process. But the
I
question
got
is,
mad
was
at the
there enough?
KKK
Colorado
mention.
had a 5-day trial. They had some live witnesses. They had a member of Congress. They took in documents. Some of it has hearsay that wouldn't be admissible. But again, it's not a criminal trial. If we look at the Maine process, there was less. That was a 1 or 2 day hearing.
Classic libs giving slavers a slap on the wrist. Now, look, listen. Fair is fair, okay? During the war period, they should have fucking slaughtered them. But once it's over, then it's understandable. I mean, they should have gotten sharper penalties, in my opinion, but you can't kill a retreating soldier. You shouldn't be able to do that. You shouldn't be able to bomb a hospital, okay? Not that so you can slaughter them without a trial. Yes, in the act of war, it's fair. Fair is fair. That's precisely what I'm saying. But after the war, if they surrendered, there should be at least more significant, more severe penalties, in my opinion. Okay? Well, yeah, you can't just like go up and murk them. Should have sent the Confederates to be slaves in the Ottoman Empire. Also, yes, there were no Geneva Conventions during the time of the Civil War, for the record. But that doesn't mean that there weren't any rules to engagement, of course. Since, even at a time when, there was Vikings and shit, there was at least, like, some level of application of, like, understood rules and shit. Obviously, it changed depending on where you were, what kind of war you were waging or where you were waging the war, but there's always been some level of standards, for sure.
The only witness was a law professor. The Secretary of State relied on documents, including YouTube clips. So the question is, was either of these enough due process? And then the final question is, and this one may seem a little odd, is the president an officer of the United States? I think logically you go, of course. There actually is an argument that's made sometimes that if you look at the construction of the Constitution, the president is actually separate from an officer of the United States. I think that one's a long shot, but look for that argument to be made as well.
Colorado will be appealed to the Supreme
Right.
Court.
Yeah.
Look, this seems to be a moment just screaming out for no ambiguity.
Yes,
And yet-
this is exactly why we have a Supreme Court. We have a massive constitutional issue. We have all sorts of unknown. We have major implications. We have inconsistency in how it's being applied. We're looking for two things. First, will they take the case? They don't have to take any case, but if Trump files that appeal today, they can tell us yes or no, we're taking it. That could happen at any moment. And then, of course, if they take it, how will they rule? Let me just say this. Nobody knows. This is uncharted territory, so it'll be in their hands in all likelihood.
Can I just to underscore that point, there is no legal precedent here.
Right.
There's nothing that people are kind of drafting off of to know how this ends.
We can pull on various strings that are out there, but there is nothing on point. We're going to get brand new law when they interpret this.
Fascinating and somewhat unsettling. Alejandro, thanks, buddy.
Thanks.
CNN's Zachary Cohen joins us now. And Zachary, help us understand the arguments being made in these appeals. What are the former president's chances?
Yeah, Audie, first, it's really important to know that the looming political calendar really is creating a sense of urgency here. And it's one of the reasons why there's this mounting pressure on the U.S. Supreme Court to weigh in on this issue, this 14th Amendment issue that we've seen come up in Colorado and again in Maine, where they say that under the 14th Amendment, Section 3, Trump should be removed from the primary ballot.
The way the media talks about the Supreme Court is literally like a pantheon of gods. It doesn't matter. You're a mere mortal. They're a pantheon of gods. Ultimately, it's corrupt, and yet everyone sees the top of the hour ad break. Supreme Court Justice Clarence Thomas is in the chat right now. He's seen the ad break at the top of the hour, unless Harlan Crow gives him a gifted subscription. That's right. Or maybe, let's say, they're lucky, right? They're lucky, and they get gifted a sub in general, like a random one that they catch. Or he has an Amazon Prime account connected to a Twitch account. They get one free Prime subscription a month. Use it here, and you won't see the 3-minute ad break at the top of the hour. Here's the 3-minute ad break now, though. They are God kings and you are a mere mortal. True.
But because he engaged in an insurrection. Now, that is already going to, the stage is set now, to go before the Supreme Court when Trump appeals this decision. He's going to ask the Supreme Court to essentially overturn the Colorado Supreme Court, state-level courts, ruling that he should be removed from that ballot. That would effectively put him back on the ballot for the primary. But, the Supreme Court has to choose whether or not it wants to take up this case. But at least this appeal will at least set the stage for that possibility to happen. Now, we also expect Trump to appeal a similar decision in Maine, where the Secretary of State there also ruled that he should be removed from the ballot. That appeal will go through state-level courts, and both decisions are on hold until the courts weigh in and this gets worked out through the legal system. But listen to what Colorado's Secretary of State said yesterday when asked about the urgency of this situation and the need for the courts to weigh in and weigh in quickly.
I certify the names onto the ballot for the presidential primary this Friday. And so we do hope that the court understands that presidential primaries are rapidly approaching and gives us a definitive answer whether or not the former president is disqualified from the ballot.
So with so much uncertainty, states asking the Supreme Court to provide some clarity, we're going to have to wait and see if they ultimately take up this issue, though it is unprecedented.
Zach Cohen, thank you.
And joining us now, former Trump attorney Tim Parlatore. Tim, we appreciate your time this morning. On the Colorado case specifically, where the appeal is expected as soon as this morning to the Supreme Court, when you think through the defenses that the Trump team would put into that appeal, what do you think is their most effective at this point?
Mm-hmm. I think really the most effective is that the state courts don't have the power to enforce this. The 14th Amendment specifically does have a clause that Congress shall have the power to enforce, and Congress has exercised that power in multiple ways. They passed a statute, 18 U.S.C. 2383, which is, they actually expanded, the reach of the insurrectionist ban beyond just, the previously elected officials to basically anybody. That would be barred from holding office, but that has to be done through a judicial proceeding in the federal court. And Congress has also acted through impeaching. They impeached Donald Trump for insurrection, and he was acquitted there. So this case has in some ways already been litigated using the provisions that the 14th Amendment, Section 5 provided.
Can I ask you about the impeachment point? Because I was struck over the course of the last couple of days that there's been some signal that the Trump team is going to utilize that, maybe not just for Colorado, but also for the Jack Smith indictment as well on election subversion. I guess my question is, I was sitting in the Senate chamber listening to Senate Leader Mitch McConnell talk about how the legal process, this doesn't do anything to change the legal process that's going to come ahead. The Senate's not going to act on this, but by all means, the courts still can. And he wasn't the only Republican to say that. Were they wrong?
So my personal belief on this is that while the impeachment does control as regards to the 14th Amendment litigation, it does not invoke double jeopardy as to criminal litigation. And so I don't think that that is going to be necessarily a winning argument of a double jeopardy to bar the January 6th prosecution. But I do think that it is going to be effective related to the 14th Amendment cases.
It's an important point, particularly as we await the appeal on that federal election subversion case. The special counsel pushed back on Trump's claim that he should have absolute immunity from criminal prosecution. Part of the argument was he threatens to license presidents to commit crimes to remain in office. I guess the question here right now is there's not a lot of precedent here, which is, you could say that about a lot of things that are happening right now. Are we in uncharted legal territory, or is there an argument here that Trump's team can actually pull on to make their point?
Yeah.
Here's why it's good. SCOTUS has to either increase the due process protections, write an opinion that totally contradicts their entire mode of thought, or write an opinion that buys an obviously obtuse argument. I suspect we'll get a split opinion that does all three. It's good to improve due process and to undermine SCOTUS legitimacy. So it's a fun time. Enjoy it. Worst case scenario is Trump can't be president. Yeah, I don't think that's the scenario that will occur, though. But yeah. My sister-in-law is becoming ultra right-wing shithead lately. How can I pull her back from the ledge without antagonizing her? Oh, my gosh, she's pulling so hard right now. Oh, Jesus. She almost got me. Oh, my God. Uh-oh, she planted. Planting.
It's definitely uncharted territory. I think that
I'm multitasking.
the
I'm a
idea
parent.
of a blanket immunity is a little bit too broad, and I don't see the courts buying that. Now, a more limited, very targeted immunity for certain acts, that I do see as being something that could win, but that's not something that really can be litigated at this stage. They would have to take this case to trial and show during the trial that what he was doing was within the scope of his duties as the chief executive. And I expect that that will be one of the things that they, can and should present to the
Bro,
jury.
give some advice for the chatter. I don't know. I don't know how to. I don't know what kind of right wing takes she has. So I don't know. I don't know how to save your sister. I need to know what is radicalizing them so I can help you.
Is that he was acting based on the information that he had, that he reasonably believed that there would be fraud, and that as the chief executive charged with ensuring that the laws of the United States are followed, that he was pushing for investigations. And if they make that argument credibly, then I think that immunity could apply at that stage, but not here.
And it seems like they're on the path to making that argument, whether it's credible or not, is still to be determined. But in that defense itself, when there's a list of dozens of people who've made very clear they told the president explicitly there was no fraud or that his theories were inaccurate, some have said that they felt like he acknowledged that was the case at various points. Doesn't that undercut that point?
Sure, and that's why it's something that really does have to go to a jury. And it's the last point that you raised there about whether he acknowledged it.
I use what I learned from Hasan to push my right friends more right. Wait, really? That's your job, is to make them even more reactionary? Good job.
That's going to be key. And so that's when you have disputed issues of fact like that, it's not something that can be decided by a judge at a motion stage. It's something that must be presented to a jury because the juries are the arbiters of fact.
It is a very busy day ahead and a very busy year ahead. Tim Parlatore, we appreciate your time as always.